Welcome, everybody. Today we're going to do the top 10 divorce questions in California. I'm going to try to answer all the most popular questions you have pertaining to divorce in California. Let's begin. Question 1. How long do I need to be a resident of California to file for divorce? Either you or your spouse must have been a resident of California for at least 6 months before you can file your divorce. So you have to have lived in California 6 months or more. And in the county that you live in, you have to have lived there 3 months or more to file for a divorce within that county. Question 2. Is California a no-fault state? Yes, California is a no-fault divorce state, meaning that you do not need to prove a fault or a blame to file a divorce in California. You can file a divorce without having a reason. Question 3. How is property divided during a divorce in California? California follows the principle of community property, generally means that assets and debts acquired during marriage are divided equally between spouses. So anything you obtain before marriage or after the date of separation is considered separate property, and everything else is community property. So if you do decide to divide unequally, which you can, it has to be by agreement by both parties. Next. What factors are considered when determining spousal support, aka alimony, in California? Factors such as length of marriage, earning capacity, financial needs, and the standard of living during the marriage are considered when determining spousal support. You can also check out Family Code Section 4320, and it will tell you all the factors that the court considers when granting spousal support. Question 5. Don't forget to like and subscribe so you can get more content like this pertaining to divorces. How is child support determined in California? Child custody. How is child custody determined in California? Child custody in California is determined based on the best interest of the child, taking into account factors such as child's well-being, the parent's ability to care for the child, and if there's any abuse or neglect involved. So it's very complex, and everybody's situation is different. So this is basically a general answer to that. Next, number 6. How is child support calculated in California? Child support is in California is determined based on a statewide guideline calculation that is considered in factors such as income of both parents, custody arrangements, and the number of children involved. If you want to do your own family code calculation or guideline calculation, you can go to ca.gov and look for the child support calculator, and you can put in the numbers and find out what estimate of how much child support would be. Okay. And number 7, can I represent myself in a divorce in California? Yes, you have the right to represent yourself in a divorce case in California. However, it is recommended to consult with an attorney to ensure you understand your rights and make an informed decision. So you can represent yourself. You can be self-represented. You can always go to the self-help center in the California courts, which should be located in every courthouse, and they will be able to help you fill out the right papers if you decide to represent yourself. Question 8. How long does it typically take to finalize a divorce case in California? The duration of a divorce case in California can vary depending on the various factors, including complexity of the issues involved and whether the case goes to trial. On average, it can take a minimum of 6 months to over a year to finalize a divorce. It can take longer, but it can't be sooner than 6 months. Can I modify child custody or support orders after the divorce is finalized? Yes. Child custody and support orders can be modified after the divorce is finalized if there has been a significant change in circumstance that justifies the modification. meaning you have to have had a change from your previous order and the reasons why you want to change it. And then it's based on the discretion of the court if they see a change is justified. Last but not least, question number 10. What is the role of mediation in California? Divorce. Mediation is a process where a neutral third party helps divorcing couples reach agreements and various issues. Mediation is often encouraged in California to promote peaceful resolution and reduce the need for court intervention. So sometimes, if you do obtain an attorney, your attorney can play this role of the mediator, but you don't necessarily need an attorney to resolve your issues through mediation or a third party. And that's all. Those are all the questions. Of course, keep in mind divorce laws can be complex, and it is essential to consult with a qualified family law attorney to receive legal advice on your specific circumstances. But other than that, good luck, and I wish you well. Until next time, bye.